We are at the top of the hour. Is it time to get started? Okay, it's 11:30. Let's go ahead and jump into. We would like to welcome you to Cybersecurity Safe Harbor, what every DFW small and mid-sized medium business owner should needs to know before you're breached. And so we would like to definitely welcome you to this session of SB 2610 Cybersecurity Safe Harbor webinar. And so before we get started, I want to go over a few housekeeping rules. Once again, we will have our guest on, but prior to getting them going, we want to talk about when is the best time for you to ask questions. So we're going to allow you to drop your questions anytime inside of the chat. Please remember that this session is being recorded and there will be a replay link that will be available to you after this particular session. We are expected to be on this particular call or this webinar approximately 60 minutes. We are going to be answering all questions on the last 15 minutes of the session, as well as we're going to be offering a complimentary discovery call for every attendee that will qualify for a complimentary discovery call to share more information about the SB 2610 that GXA will offer. And we will be providing more details at the end of this particular webinar. So welcome again to SB 2610 Cybersecurity Safe Harbor. My name is Dr. Alicia Makaye. I am the co-founder as well as the Chief Outreach Officer for GXA. Just a little bit of information about myself. I'm an Air Force veteran. I have, of course, been with GXA since the beginning, so over 20 years now. And however, I am going to just be here to moderate this wonderful conversation. So let's get started and let me introduce our speakers. One of our first guests today is going to be a partner and cyber attorney. His name is Jeremy Rucker. Jeremy, I would like to definitely send the warm welcome to you, and would love for you to share a little bit about yourself and provide an audience with a brief hello.
Thanks, Alicia. Hello, I'm, as you mentioned, Jeremy Rucker, and I'm a data privacy and cybersecurity attorney at the law firm Pearson Ferdinand. I assist organizations of all sizes with their data issues, whether it's on the front end before a data incident occurs, with privacy and cyber compliance, or on the back end after a breach occurs, acting as a breach coach to guide organizations through incident response efforts in a legally compliant manner. It's a pleasure to be before you, and I look forward to talking to you about this Texas legal update.
Thank you so much, Jeremy, and welcome to the SB 2610 Cybersecurity Safe Harbor webinar. So next, I would like to introduce our next guest, which is also George Makaye. We share the same last names because he is also my business partner as well as my spouse. And he is the CEO of GXA. And of course, we are located in Richardson, Texas. We are a MSP, a managed service provider here in the local area. I'm going to pass the mic over to George and allow him an opportunity to say hello and tell us a little bit more about what he does.
Thank you, Alicia. George Makaye, as Alicia noted, I'm the co-founder and CEO of GXA. Alicia and I started the business together 22 years ago. So we are, as Alicia alluded, we are an IT consulting company. We're based in Richardson. We provide outsourced IT and cybersecurity services to small, medium businesses. Most of them are based in Dallas-Fort Worth. We serve these businesses. They're all from different markets. We provide, the services they need and also help them modernize their technology and make sure that, they stay compliant and they stay secure. I'm just glad to be here, glad to talk about this topic, and looking forward to having further conversations.
Thank you, George and Jeremy, for joining us. So let's go ahead and jump in and take a deep dive into SB 2610. At this time, I'm going to turn it over to Jeremy, and he's going to kick us off.
Thank you so much. So for the next hour or so, we're going to walk through one of what I feel is one of the most significant pieces of cybersecurity legislation to come out of Texas in recent years. And this is the Texas Cybersecurity Safe Harbor law, which is codified in Chapter 542 of the Texas Business and Commerce Code. So this law, which became effective on September 1st of last year, establishes a framework that essentially incentivizes small and medium-sized businesses to adopt what's termed recognized cybersecurity standards. So in exchange for that proactive investment, qualifying businesses receive certain legal protections from exemplary or punitive damages in the event of a data breach and resultant litigation. Over the next 45 minutes or so, we'll cover some of the problems we'll cover the problem that this legislation aimed to solve, the specific protections it offers, who qualifies, and what's required to afford yourself those protections. But before we dive into the details of the law, I briefly want to discuss the why and why it exists, because that why is critically important here. Cyber attacks impose a staggering financial toll on American businesses every year. We're talking about billions of dollars in losses annually. But here's the key point. Small and medium-sized businesses are the most vulnerable target. It kind of sounds counterintuitive, but that's the truth. Why is that? Well, because they typically have limited budgets, smaller IT staffs, less technical expertise to implement these sophisticated cybersecurity defenses. And attackers know this. So they've increasingly shifted their focus from hardened enterprise targets to the softer targets represented by small businesses. And when these attacks succeed, the damage cascades through three primary channels. So we have direct losses, right? That includes the stolen funds, ransomware payments, the immediate cost of the breach itself. We also have indirect costs, which go beyond the immediate direct losses, which includes the items such as the prolonged operational downtime. During that time, systems typically need to be rebuilt. There's forensic investigations for legal purposes that need to be conducted. And sometimes notifications are required to be sent to impacted individuals under applicable law. Then last, there's reputational harm, right? So this perhaps the most insidious damage to an organization is the erosion of customer trust. When customers learn that their personal information was compromised, they may take their business elsewhere. So for many small businesses, a significant cyber incident is just not a simple setback. It can be an existential threat. The Texas legislature recognized this reality. And then the question became, how do we encourage businesses to invest in cybersecurity without creating new burdens that could themselves harm the small business? And the answer was this SB 2610, which establishes that legal safe harbor for businesses that proactively adopt those recognized cybersecurity frameworks. So, let me kind of explain what I mean by, or what the law means by a safe harbor in this context. So when I'm talking about a safe harbor in the legal context, it's that concept that provides protection from liability, or in this case, from a particular type of damage when certain conditions are met. So it's essentially the law saying, if you do X, Y, and Z, we'll protect you from certain consequences. And here's the key protection under this bill. So businesses that implement and maintain qualifying cybersecurity programs are protected from exemplary damages, which are also known as punitive damages, depending on who you ask, in lawsuits arising from a data breach. So now let's be precise about what that means and what it doesn't mean. So exemplary damages are awarded as a penalty or by way of punishment. So essentially, they're designed to punish egregious conduct and deter future misconduct. They're specifically not compensatory, right? They do not represent actual harm to a plaintiff. So under the safe harbor, if a qualifying business suffers a data breach, despite maintaining an appropriate cybersecurity program, plaintiffs cannot recover exemplary damages from that business. However, and this is very important, the safe harbor does not eliminate all liability. Plaintiffs can still pursue actual economic damages, compensatory damages, or other various remedies that are available under the existing law. Uh, so essentially, this safe harbor is a shield against the punitive component, not complete immunity from all consequences of the breach.
All right. Thank you, Jeremy. That was great explanation. I want to take over this slide, and this slide is really about urgency. As Jeremy alluded, SB 26 matters because cybersecurity is no longer just an IT issue. It's business risk, it's legal risk, it's insurance risk, and in some cases, existential risk for small, medium businesses, as you can see the numbers here on the screen. And small businesses are targeted for the same reasons that Jeremy noted, that there are fewer resources, smaller teams, you have less mature security controls than larger enterprises, and you're more under pressure to actually pay for ransomware when that becomes the case. In addition to that, the impact of a breach can be significant depending on the type of breach, because you have to look at it's not just the ransomware payment that you make, it's also the downtime, the lost revenue, the legal expenses, the forensics costs, and notifications you have to send out to your clients, reputational damage, and things like that. So I think this is where SB 26 has become important, because then it gives Texas businesses a reason to go ahead and implement some of these controls and have some protections under the law. So obviously the key here is it's before a breach. So these are things you've got to have before the actual incident happens, not after. And so the goal is to be always make sure that small businesses are prepared and they put these measures in place before actually an actual breach happens, so they can satisfy the law. Jeremy, I have it take.
Here we go. Okay, so who can take advantage of this safe harbor? Well, the law sets two threshold requirements, right? The safe harbor applies to Texas business entities that first have fewer than 250 employees, right? And this is a hard cap. So if you have 250 or more employees, this safe harbor does not apply to you. The legislature specifically designed this protection for small and medium-sized businesses, the entities that are most vulnerable to cyber attacks and least equipped to absorb the cost of implementing enterprise-grade security. And second, the safe harbor applies to businesses that own or licenses computerized data that includes sensitive personal information. So this means that the business must actually possess or have access to the type of data that triggers the law, right? And sensitive personal information is defined elsewhere in the law, and it generally includes things like social security numbers, driver's license numbers, or financial account information, or medical data. So if your business meets both criteria, fewer than 250 employees and possession of sensitive personal information, then you're within the scope of this law, and you can potentially claim the safe harbor if you implement a qualifying cybersecurity program. Now, I want to be clear that this safe harbor only protects against exemplary damages, right? And again, exemplary damages means damages awarded as a penalty or by way of punishment, but not for compensatory damages, right? The Texas statute defines exemplary damages. The Texas statute that defines exemplary damages explain that those damages are neither economic, which are those intended to compensate a claimant for actual economic loss, nor are exemplary damages non-economic damages, which are damages awarded for the purpose of compensating a claimant for things such as pain and suffering, or mental anguish, or injury to reputation. So when we talk about the safe harbor protecting businesses from exemplary damages, we're talking about protection from the punishment component of a damages award, or the amount that goes beyond compensating the plaintiff for their actual losses. In major breach cases, um, punitive damages can dwarf compensatory damages. They're often where the largest exposure lies. And that's what makes this safe harbor meaningful. It addresses the component of damages that can be most unpredictable and have the most devastating impact to a defendant. George, I'll turn it back over to you.
Thank you, Jeremy. All right, so let's talk about the compliance tiers. And the way the SB 2610 is written, essentially, there are 3 compliance tiers, and it's based on the size and complexity of your organization. So the law recognizes that a 10-person company that has maybe 1 office, 10 computers, nothing complicated, cannot have the same level of complexity of controls as a 250 user company that has more robust infrastructure, maybe higher risk, complex, systems in place. And so the law tiers the compliance based on the size and complexity of the organization. The first tier is for organizations that have 20 employees and under. And essentially at this tier, there are only about 16 core controls that you have to put in place. And it's all about having reasonable security. And essentially, for example, you want to make sure that you have written policies and have those policies mapped back to the controls that you have in place. And then there are some fundamental technical safeguards or technical controls that the law requires you to have in place. For example, multi-factor authentication, password policies, access controls, training program for your employees, and having all this kind of formalized process in how you run your cybersecurity program. So even though it's not very robust as a large organization, it's about formalizing these controls and formalizing your security program. The second tier applies to organizations that have between 20 and 99 employees. And obviously here, the compliance and requirements have scaled up a little bit. They're more structured because organizations of this size, they typically have either multiple locations, they have more users, so there's obviously a bigger threat landscape. They have more vendors that they're working with, sometimes sharing data, some sensitive data with these vendors. And so in addition to the core controls that are required in tier 1, there are additional controls that are going to be in place where you have more robust security policies, you have more robust technical controls like asset inventory and web filters and vulnerability management, and having a documented incident response plan. And many times for tier 2, the goal is to align with a recognized security framework. For example, CIS implementation group 2 is a good one that provides guidelines on how to implement reasonable security within your organization. The third tier is for large organizations, 100 to 249 employees. And here the requirements scale significantly higher because, again, these organizations have a much more complex infrastructure. They typically would have compliance requirements, or they might have sensitive data. They have a lot of data. And so the goal here is that for these organizations, there is a much more robust security program that's required for them to comply with SB 2610. This is where we see things like implementing a full risk assessment, a formalized full risk assessment, having third-party vendor risk assessment being performed on a regular basis, obviously having 24/7 security monitoring in place, having what I call annual security meetings. For example, having the formal security meeting, having a quarterly security meeting with your leadership, and having those meeting minutes in place, as well as having these security ceremonies, for example, tabletop exercises where we are testing our security defenses, having penetration testing, third-party vendor risk, reviewing your policies on an annual basis. So at the tier 3, there's a lot more complexity in terms of the things you have to do to comply with the SB 2610 versus the small organizations. If you have 20 employees and under, or under 20 employees, they are more basic. And I think that the essence of this slide is to answer a question where if you're a small business, let's say you're a small business, it might feel like, oh, to comply with this law, I have to do all these things. I have to invest a lot of money to be able to be compliant. But the reality is you don't have to. If you're a small organization, you have a simplified infrastructure. The controls and the requirements are a lot less than if you're a much larger organization. But also, if you're a large organization, then it means just having basic policies, basic controls does not mean that you're going to comply with SB 2610. You actually have to have a much more robust security program in place. All right, so this slide, this is where we take the SB 2610 from more the legal language into the real world. In essence, when we've surveyed small medium businesses in Dallas, Fort Worth, we find that about 80% of those businesses do not currently meet their tier or framework requirements. We also find that most small businesses think that they actually comply or they're in alignment just because they have backups and they're doing IT monitoring, they have some password policies and multi-factor authentication, and they think they are compliant and they align. But then when you go in and you do an assessment, we find some major gaps. And the key issue here is SB 2610 is about having a formal program in place. Just because you have tools in place, you're doing monitoring and you have password policies or you have multi-factor authentication, does not mean that you actually can you align and comply with the law. It's about having a formal security program in place. Many times, small businesses have their security program is informal. It's not documented. It's inconsistently applied across the different systems and the business. Also, there's no evidence to show that these controls are actually operating. So as an example, the common gaps that we see is having no written security program document or security policy. And at the most basic definition of a security policy, this is basically a document that outlines the framework that you're following. This is a framework a security program follows. And these are the controls that we have in place. And these are the people who is responsible and accountable for those controls. This is how we review the controls. And then here's evidence that actually the controls are operating. So having this document in place to help formalize that process. The other common gaps that we see is where the controls, that it could be the technical or administrative controls, they're not consistently applied across the organization. So for example, multi-factor authentication may be applied on some of your key systems, but they're not applied to some of your legacy systems or some of the admin accounts. Or it could be the password policy might be applied for some of the users, but not consistently across all the users. The other common gap that we see is when you talk about SB 2610, which is a law, in a legal setting, it's all about having evidence and be able to prove that you have these things in place. And so just saying that we train our employees is not sufficient. It's about being able to produce training logs. It's about showing that we have 25 employees, and last year we trained all the employees, and here's a log showing that all the employees were trained. Or last year we hired 5 employees, and then they all went through the mandatory security awareness training that's required, and they signed off. If we have policies, then here are the policies, and they've been signed by leadership. And so it's about having this paper trail in place to ensure that you can demonstrate and you can actually prove that the program is in place. The other big gap that we see is not having a documented incident response plan. And an incident response plan is key for any business, because this is where you outline what happens in the event you have a breach or you have an security incident. Have you documented in the event you have a breach, how do we respond to the breach depending on the type of breach? How do we notify our clients? How do we communicate with the employees? How do we protect any evidence, right? How do we make sure that, for example, that we're notifying a cyber insurance or we are notifying the legal team? So having this document and plan in place and make sure that in the event you have a breach, you're following this program, this plan, versus trying to figure this out as the incident is happening. And then cyber insurance is a common gap that we see where people say, "Oh, I have cyber insurance, so why do I need SB 2610?" And as Jeremy, alluded to earlier, cyber insurance helps with some of the recovery costs and things like that. But SB 2610 is about covering your, the actual compensatory, costs around the breach and then the punitive damages. So it's important to know that those are two very different things. And the reality is having cyber insurance, having SB 2610, most of the controls when you are applying for your cyber insurance, you're going to have a questionnaire, and generally they're asking you about, do you have this in place? Do you have MFA? Do you have password policies? Those are generally the same controls that you're going to have in place to have SB 2610. So going after and ensuring that you're aligned with SB 2610 actually helps you with your cyber readiness, so to speak. So how do we get there? And this is I'm going to walk you through the path to compliance, and it's not as complex as most people think. It's actually pretty straightforward. The first step is really a discovery call. And this is where, for GXA, we sit with our clients or prospects, and we just have a conversation about their business, about their IT environment, talk about some of their priorities, and assess their SB 2610 exposure. The goal is to identify what your tier that applies to you, and then what is a good next step from a high-level standpoint. And the discovery call is offered for free. And then their security assessment is the next step, where we essentially are going to do a security maturity assessment, high level, going through all the controls, and then giving you an executive report that you can look at and see from a scale of 0 to 5, this is how I scale, and then providing you with an executive summary that you can take with you. We also give you an information security roadmap. Basically, it's a 12-month, up to 12-month roadmap that outlines, prioritize the things you should focus on first, the things you should focus on second, and what's important. And then you can take this roadmap and either apply it internally, or have your IT provider or GXA can also help with the implementation. So here are some of the questions we hear from prospects or clients when we talk to them. One of them is, we are too small to be a target. And as Jeremy noted, smaller businesses are actually a softer target than large organizations. Ransomware groups or threat actors typically target the weakest link. They target people who have the least controls. And so it's important to know that just because you are 5-user company or 10-user company, you actually a target for cyber breaches. So the second one is, people will talk about our cyber insurance covers us. And Jeremy, I'll let you talk about that.
Yes. So hear this all the time, right? And cyber insurance is extremely valuable, right? I'm not sitting here telling anyone to cancel their insurance policy, but cyber insurance is not a substitute for cybersecurity, and increasingly the insurers kind of agree with me. First, insurance, it doesn't prevent the breach, right? It helps you recover financially after one occurs, but the operational disruption, the customer notification process, the forensic investigation, the reputational damage, all of that still happens. And, insurance may cover some of those costs, but it doesn't make the breach unhappen, if that makes sense. And, your systems are still down, your customers still angry, your reputation is still damaged. Second, cyber insurance policies have significant exclusions and limitations. And, I urge you to take a close read at your current cybersecurity policy. Most of these policies exclude things such as breaches resulting from the failure to maintain minimum security standards. They exclude unpatched or known vulnerabilities, social engineering attacks. Every year, these exclusions get longer and longer. So, if you suffer a breach because you failed to patch, for example, a known vulnerability or didn't have basic security controls in place, the your insurer may deny the claim entirely. It's become a known fact that cyber insurance is becoming harder and more expensive to obtain. Uh, insurers have gotten burned by the recent explosion in ransomware claims, and they're now requiring evidence of security controls before they'll even write those policies. So, the whole our cyber insurance covers us. That's a known misconception at this point.
Thank you, Jeremy. The third one misconception we hear is that we are HIPAA compliant, or we are compliant with this regulatory framework, so we should be fine. The reality is being compliant and being secure are generally two different things, but also as pertains to HIPAA compliant, HIPAA can satisfy SB 2016, but only if it's fully implemented, and not just obviously having the policies in place, especially in healthcare, but also those controls are documented. You're reviewing those. HIPAA requires that there are annual security assessments that are being performed. You're identifying gaps, and then you're building a roadmap throughout the year to ensure that you're addressing those gaps. And then you have, obviously, training is in place, and you're training all your employees. So if you follow HIPAA to the law and you do it right, it could satisfy SB 2610, but it doesn't always mean that just because you're HIPAA compliant that you're actually fine. The other one is, we'll get to it next year. SB 2610 does not apply retroactively. It's about having the program in place before the breach happens. And so waiting till later might actually work against you, because in the event you get compromised between now and then, then you're not going to be compliant. You're not going to align with the requirements, and might be exposed to expenses around punitive damages.
Yeah, and kind of to add to that last point there, George, and I think you can probably talk more to it, but implementation of these controls take time, right? Standing up a cybersecurity program is not a weekend project.
Yeah, that's true. That's true. As I kind of mentioned earlier, building a roadmap is important, because there are, one is small businesses have limited budgets, and so you're not going to be able to implement all the controls at once. And so you have to prioritize those controls. And so having a road, doing it earlier so you can get started, understand what are the gaps, the totality of the gaps that I'm exposed to, and then prioritizing those, the plan of action, so that based on your budget, here's the things that I need to tackle this year. Here are the things that can actually wait till next year, and ensure that you're working towards alignment with the law. And so the sooner you can get started, the better, because then at least you know where your exposure is, and then start mapping out, how do I start to tackle this gap over time.
So Jeremy and George, we would like to thank you so much for sharing your expertise inside of around this particular topic. So now we want to take questions and answers from our audience. We would love to hear from you. We have some questions that are in the chat. So Jeremy and George, please hang tight while I go over the questions that have been presented to us today on regards to this particular webinar. So one of the first questions that we have today is, how documented does the program have to be to hold up in court? This is a two-part question. Is it a written policy? Is a written policy enough? Or how much evidence do we need, or how much training do we need in regards to audits, etc.?
Yeah, and that's an incredibly tough answer, tough question. So I'm going to give the lawyer response to everything, right? It depends, right? So if we're talking a smaller organization, then naturally the bar will be lower. If we're on the upper end of the organization with closer to that 250 cutoff, then the requirements will be a lot more. But I will say, what I always tell my clients is that we have to give enough of written documentation to where we can persuade not only courts but also regulators, right? Because not only will you have courts and following a breach, you will not only have the courts to deal with, but you'll be dealing with regulators and things like that. So it's a matter of being confident in what you have and what's written and what's actually in place. And it's not as easy as giving a simple answer as the document must be 1 page, 2 page, 3 page. It's all dependent upon the type of information that's impacted and the risk profile of the organization.
Thank you for that information. I'm going to go to our next question. We have customers in California and New York. Does SB 2610 only protect us in Texas court, or does it travel?
Sure. So as we currently know, right, this is a new law that hasn't been challenged in the courts, but based on other laws, I can confidently say that it only protects organizations here in Texas, right? When we're talking about data breach notification laws in particular, those are consumer statutes. So the laws of the state in which the individual resides would apply to the information of that individual in that state. So if we have an individual here in Texas, it's clear, right? This law would apply to the organization. However, if we have someone, for example, in California suing, it'd be harder to make that connection because California law would govern that litigant. So we'll see exactly how it shakes out here in the next couple of years. I'm confident that we'll get some court challenges on that point, but as it stands now, only Texas.
Okay, we have another question. We have an IT person. Can they implement this, or does it require an MSP?
That's a great question. What I can, obviously, depending on the tier, because the complexity scales as you go from tier 1, tier 2, and tier 3. And so depending on the tier, depending on the technical expertise of the individual that you have in-house, yes, an internal IT can definitely implement the controls. It just really depends on the expertise that they have and the tier under which you fall. Also, the other thing to note is that SB 2610 is not just technical, right? It's not about having, again, the technical controls, the multi-factor authentication, the password policies, the security hardening. There are also administrative controls around making sure you have the meeting minutes, you have policies, you have training program in place, and things like that. So there are aspects of having a mature security program or a well-documented security program that fall outside of the realm of the IT. And so it's sometimes helpful to have an external IT or security provider kind of guide that process, just because then they can provide the guidance, but also help with the implementation, as well as be able to support the internal IT person in the event that they have any questions. But yeah, so if you have a strong IT resource internally, they can implement, especially the technical controls. They have their senior engineer, or their kind of a senior sysadmin. They can implement most of the technical controls. But it's about looking at all the other requirements beyond just the technical aspect of the law.
Thank you. Here's the next question. We're 18 employees today, but planning to grow past 20 this year. Should we build to tier 1 or skip ahead to tier 2?
That's a great question, because there'll be several businesses that kind of fall between the tiers. And what I would recommend is obviously go ahead and just prepare to align with the higher tier, because if you're going to grow to that tier anyway, why not just go ahead and start there? And again, the reality is, to fully implement a robust or formalized security program takes time. There are things you're going to do, you're going to really, budgetary wise or time wise, you're only going to be able to implement this year. and there are things that will fall will be scheduled and moved over to next year. And so if you're planning to grow anyway, and you're gonna have 25 employees next year, go ahead and just go ahead and implement the tier 2 instead of tier 1.
Okay, that was the last question that we had. Before we close it out, Jeremy or George, do you have any closing comments or suggestions?
Absolutely. So, as we kind of wrap up today, just want to leave you with a couple of takeaways, right? So, first, this threat is real. Cybersecurity threats are real, and it's not going away anytime soon. Cyber attacks on small and medium-sized businesses are increasing in frequency and sophistication. And the question isn't, whether you will face a cyber incident. It's when, and will you be prepared when it happens, right? Second, Texas has created this meaningful incentive, right? This safe harbor isn't just another compliance burden; it's actually an opportunity. That protection is valuable, and you should certainly take advantage of it if you can. And third, and as mentioned by George here, the time to act is now, right? Implementation takes time. Every day of delay is a day of unprotected exposure.
Yeah, so the one thing I was going to add to Jeremy's comments is that think of this as a way to help you mature your security. This is an opportunity for you to mature your security program, because SB 2610 provides a framework where you can measure as a business owner. A lot of the times we're not technical people, or you have technical expertise, but this gives you a framework that you can measure the maturity of your security in place. And as we stated before, cyber breaches and incidents are not just an IT issue anymore. It's really a business risk. So if you're a CEO of a company or an IT or a leader of a company, how do you measure and how do you know that you're either compliant or you actually have reasonable security in place? And so SB 2610 gives you a framework against which you can implement a robust security program, and then know that have evidence that these things are actually operating. So we have to look at it from, okay, there are benefits obviously from a protection against punitive damages, but also it allows me as a business to mature this aspect of my business, because I need to reduce risk. I need to make sure that I'm mitigating, business risk and legal risk and things like that. And this is a good framework to actually implement to ensure that these things are in place.
Thank you for those closing remarks, George and Jeremy. So I would like to remind everyone, first of all, thank you so much for joining us today. But we are here to serve you, and we are here to help. By coming and joining this call, what we're offering today is a complimentary SB 26 discovery call. This is going to could potentially save your business thousands of dollars, as along with a lot of emotional pain that would come along with getting a cyber breach. And so what you get with the SB 26 and 10, you get a 30-minute call with GXA cybersecurity expert, identification of your SB 26 tier, because remember, you have 3 tiers that you're supposed to consider before you actually enroll in an SB before you are compliant with SB 2610. You also get a high-level review of your current security posture, and you get a clear next step towards your safe harbor. This is no cost to you. We're here to serve you and to serve your organization. We want you to be safe. We want to protect you in the industry. We want to make sure that you're able to deliver the services that you actually are offering to your clients. And we're here to actually support you in what you do. So we would like to once again thank you so much for joining this particular call. We would like to give a greetings again to all the guests that joined us. Thank you for joining, as well as our guest speakers, Jeremy and George, for coming and being with us. Once again, I want to remind you, this replay will be in your inbox within 48 hours. We appreciate you and have a wonderful day. Thank you.